Hello, everyone, and welcome to Internet Law Review. For today's story, we are covering the United States Supreme Court case of Nutraceutical versus Lambert. This is a case dealing with a procedural question, namely, when does a certain time period start and when does it stop? And this is a question that comes often up in law, most notably in statute of limitations cases. In many criminal cases, there is a statute of limitations that requires the government to bring a charge within a certain period if it's to be brought at all. And in statute of limitation cases, there's often questions about when that time period starts, and perhaps even more importantly, if it stops or pauses for any particular reason along the way. And this is a case, although not in a criminal case, that deals with a similar question. When does a certain time period start? Does it pause for any reason? And when does it end? So let's see what the specific issue is here and how the Supreme Court wants to resolve it. Respondent Troy Lambert filed a class action in federal court alleging that petitioner Nutraceutical Corporation's marketing of a dietary supplement ran afoul of California's consumer protection law. On February the 20th, 2015, the district court ordered the class decertified. Pursuant to the Federal Rule of Civil Procedure 23F, Lambert had 14 days from that point to ask the Court of Appeals for permission to appeal the order. Instead, he filed a motion for reconsideration on March the 12th, which the district court denied on June 24th. 14 days later, Lambert petitioned the Court of Appeals for permission to appeal the decertification order. Nutraceutical objected that Lambert's petition was untimely because it was filed far more than the 14 days from the February 20th decertification order. The Ninth Circuit held, however, that Rule 23F's deadline should be told under the circumstances because Lambert had acted diligently. Told is just another word for paused. On the merits, the court reversed the decertification order. So, the question is set up. In the Federal Rules of Civil Procedure, when it says 14 days, what exactly does that mean? And can it be paused or told for any reason along the way? So let's see what the Supreme Court has to say. Held, Rule 23F is not subject to equitable tolling. Rule 23F is properly classified as a non-jurisdictional claim processing rule, but that does not render it malleable in every respect. So the distinction between jurisdictional and non-jurisdictional rules are very important, because if a rule is jurisdictional, that literally means it would deny the court jurisdiction, authority to hear the case. And that does come up quite a lot. But there are other rules that are non-jurisdictional. In other words, they are meant for the convenience of the court, but they do not in and of themselves prevent the court from hearing the case. And sometimes in non-jurisdictional rules in particular, they can be modified for considerations beyond what the rule specifies. But here the Supreme Court is saying that that does not make them infinitely malleable. Continuing, the Supreme Court says, whether a rule precludes equitable tolling turns not on its jurisdictional character, but rather on whether its text leaves room for such flexibility. Here, the governing rules speak directly to the issue of Rule 23F's flexibility and make it clear that the deadline is not subject to equitable tolling. While Federal Rule of Appellate Procedure 2 authorizes a court of appeals for good cause to suspend any provision in a particular case, it does so with a caveat, except as otherwise provided in Rule 26B. Rule 26B, which generally authorizes the extension of time, in turn includes the carve-out that a court of appeals may not extend the time to file or a petition for permission to appeal, the precise type of filing at issue here. The rules thus express a clear intent to compel rigorous enforcement of Rule 23F's deadline, even where good cause for equitable tolling might otherwise exist. Precedent confirms this understanding. Lambert's counterarguments do not withstand scrutiny. Lambert argues that Rule 26B's prohibition on extending the time to file a petition for permission to appeal should be understood to foreclose only formal extensions granted ex ante. Ex ante means before, so you'd have to ask for it before something occurs, and to leave courts free to excuse late filings on equitable grounds after the fact. So he's arguing that you can't ask for permission in advance, but you can ask for permissions after the fact. Okay. Continuing, the Supreme Court says, but this court has already rejected an indistinguishable argument concerning Federal Rule of Criminal Procedure 45B in Robinson, and Lambert offers no sound basis for reading Rule 26B of the civil rules differently. Further, the 1998 Advisory Committee notes to Rule 23F speak to a court of appeals discretion to decide whether a particular certification decision warrants review in an interlocutory posture, not to its determination of whether the petition is timely. Interlocutory means that the case is still going on. Normally, in trial cases, you cannot appeal the case to the Court of Appeals until the case is finished. A final verdict is rendered, for example. If you want to appeal while the trial is still going on, that's what's called an interlocutory appeal, and they're normally not allowed. However, the rules do set out certain things that can, and in fact must be done in an interlocutory position because they go to fundamental issues that cannot be cured after the fact, and this is one such thing that can be reviewed in an interlocutory way. So if the court denies the certification, rather than going through the entire expense of a trial and then appealing, because that would be a little bit silly, you can just immediately ask the Court of Appeals for permission to have an immediate review to review that determination right away, so you don't have to go through the expense of a trial only to throw out that result completely and to have to do it again. Finally, Lambert notes that every Court of Appeals to have considered the question would accept a Rule 23F petition filed within 14 days of the resolution of a motion for reconsideration that itself was filed within 14 days of the original order. Although his own reconsideration motion was not filed until after the initial 14 days had run, he cites the lower court's handling of such cases as evidence that Rule 23F is amenable to tolling. However, a timely motion for reconsideration affects the antecedent issue of whether the 14-day limit begins to run, not the availability of the tolling itself. On remand, the Court of Appeals can address other preserved arguments about whether Lambert's Rule 23F petition was timely even without resorting to tolling, reversed and remanded by Justice Sotomayor, writing on behalf of a unanimous Supreme Court. So, that is the case of Nutraceutical versus Lambert, a case deciding the federal rules of civil procedure and the federal rules of appellate procedure. Under these rules, they set out certain time periods, and the rules also say that courts can waive certain time periods for good cause. However, the rules do specifically prevent courts from extending time periods in certain circumstances, such as this immediate issue. And therefore, the Court of Appeals, according to the U.S. Supreme Court, was without power to extend this time period because the rules did not give them the flexibility to do so. So, a pretty simple rule, a pretty simple carve out, the Ninth Circuit ignored, and for the second time in 2 days on this channel, I cover a case where the Ninth Circuit was overruled unanimously. So perhaps the United States Supreme Court is going back to form where it just would overrule the Ninth Circuit all the time. This has been less true in recent years, but perhaps that's coming back. We'll see how this develops. But for now, my friends, that is all. I hope you're well, and until later, cheers and goodbye.